Thank you so much. So quickly, we'll jump into the next class for today, and that's professional ethics. Today is our topic for today is practically on drafting principles, closing of files, and I hope that we're able to touch a lot of it because there are quite a lot of things that have to do with drafting principles in professional ethics. So I hope that the time will allow us, and in fact, I think Michael has given us some extra time, so we will maximize it towards covering a lot. So like I just said, we'll be treating basic drafting principles in professional ethics, closing of files, and if time allows us, we'll go into, legal research. I think time allows us, we'll go into the legislative drafting, hopefully. So I'll just start quickly to see how much we can cover. And before I start, I want to ask, is there any of us that have taken our time to actually read any of this, or maybe have an idea of it? Anybody? Has anybody taken our time to read this? Okay. Okay. So I'll just make it as rudimentary as possible so that we can easily understand and gain quite a number of things. So I know that we are all on court extension. Chamber attachments, and put it that way. And to be fair, the bulk of what is done in chambers is drafting, besides the court part where they have to, in quote, play out what they have written in their chambers. And to be fair, the strength of every lawyer is how much they're able to, or how best they're able to draft. And drafting might look simple on the surface, but I'm sure that from your essential experience, you might have seen how lawyers act when they do draft. So I'll just take you through some of these principles today. So basically, what's legal drafting? Legal drafting is the art of legal writing, preparation of legal documents, representing the client's intentions in written words, communication in permanent form. And I think in during your chamber assignment, you have seen quite a number of documents that some of these lawyers have drafted in chambers. One of such you'll see is maybe say a motion for people that work in a litigation firm, motions, notice of appeals, affidavit, written addresses, legal opinions, letters, wills, deeds, and so on and so forth. So there are a lot of things that lawyers do draft. That's why, as much as possible, we must be very careful with some things that we do when we draft. But what's the point of drafting? Is to basically to aid clarity and accuracy so that you represent the client's thought as is, even while you are being wary of your adversary's line of thoughts or battle lines. So for legal documents, when you are drafting, one thing that you should be very aware of is that those documents should be clear and unambiguous. You don't want to be using legal jargons that whether it's you or the judge or any other person will not be able to fully understand what you are saying, or they might even misquote you. So those are things that we should pay attention to when we are drafting. Ensure that your legal draftings are clear, unambiguous, articulate, precise, and then in the order that you are presenting what you are drafting, it's very clear, sequential, it flows, and that you're able to articulate your client's intention in the most simple manner, plain, and use of precise words. So again, with all the law is said, what should you avoid when you are writing? Avoid unnecessary length of words, like words that are not necessary, that can even misquote what you mean in that draft. Avoid it. And that's an information that you should also use active voices, not passive. So what I mean by active voices, you're going to be speaking in first person pronoun as against speaking as if you are passing somebody's thoughts. I don't know if you've heard in I think it's in civil or in criminal, when they talk about hearsay evidence, you don't want to be talking as if you are saying hearsay. So that's why I say you choose active words when you are speaking. Don't use unnecessary words. Don't use uncommon words like jargon that nobody really understands. That only understands. You're not trying to prove intellectualism in your write-ups. Yes, your writing should be intellectual, but it should not be ununderstandable. So that's how I was reiterating unambiguity when you are writing. Are we following? Am I too fast? Are we following? Okay, thank you very much. So I'll proceed. Use present tense, draft in singular, use paragraphing to help people follow your order. I mean, or your reader follow your orders in your write-ups. Try not to use archaic words or expression like, for example, using aforesaid, herein, therefore, witnesses, like those kind of words that can easily create confusion. Try to minimize the use, except where it's like absolutely necessary. If it's not, you can do it with those kind of expressions in your drafts. So avoid verbosity. What I mean by this is using unnecessary words. For example, upon due, hereby assign. Like some of these words are very, very complex, and most of us might have seen this in like all those old drafts of deeds. When you see some people writing some words, say maybe herein, therefore, yeah, after, therewith. I'm like, you can make it as simple as possible. The point of why you're writing it is not it's to make, for example, when you're no longer there as a lawyer, for me people to be able to like parties to be able to say, oh, this is what my lawyer meant. Not that they will have to call you as a lawyer to come and explain what you wrote in this thing. That's not your motive in your writing. I'm not supposed to show professionalism. So those are things that you should take note of when you are drafting. Again, avoid clumsy expression. Be concise. Avoid inconsistency. So if you are using some words, maybe you're going to use feyi ella, and then over time you now use only feyi here. The next place is ella. Before you know it, you will confuse people because they're wondering who exactly is feyi ella. Who is feyi ella different from feyi? Is feyi ella different from ella? So like try to be very consistent in your words. So a very good example of this is where you are saying that maybe you're using acronyms. In fact, in your exam, maybe you're using acronyms and you wrote an acronym, let's say KAMA, and then you now wrote maybe C in the next word. People now don't know what is KAMA. You use KAMA, you use CD. You should exactly one exactly what to use. So try to be as soon as possible. Try to be consistent. Another example is when you are drafting, maybe say you're drafting a written reference in court, where you address a party here as his full name, and the next part you say is first claimant, and then in that same breath you should call him first. You should call him his name again. Before you know, people start to be confused. So if you are going to be using one expression, you can say, okay, if this person in maybe in later this write up will be referred to as first claimant. That way, nobody will be confused as far who is first claimant in your write up, even without reading so much. So try to be consistent when you are writing. Also, avoid redundant words like null and void and of no effect, except where you are going to use it compulsory, except where it's very important or is part of their instruction. So also, improper use of words. I think this is a place that you must really pay attention to. Improper use of words. I don't know if I've heard about a person like shall, may, every, such, and how this can cause confusion in write-ups. So normally, words like shall connotes obligation. It connotes that this thing is mandatory. Sometimes they may use it to mean discretionary, but generally it means that thing is obligatory. Also, when you use words like may can be mandatory, may can be discretionary, depending on how it is used. Don't just say that, oh, may means because how may is that they give me option. May might be mandatory. You might see a word, an expression where they use may, and it has the same effect as shall. So just be context sensitive. Another one is using an or and, or a or an, a/an. These are indefinite articles. Sometimes to show authority, you want to use d, that is the, instead of a or an. If I say that a boy or the boy, you get what I mean. Another expression is when you use every. So usually every means like you are singularly counting like a singular countable number, something like that. So you are saying every boy. So you're telling everybody that, okay, in this context, every boy. Unlike when you're using words like ish is going to be person specific in that kind of expression. I don't know if you understand what I'm trying to say in my differentiating between each and every. Do you understand? Before I proceed, okay. Thank you very much. So I'll proceed. Another one is when you're using such in your drafting. Most time when we use such, we're probably referring to something specified in that write-up. But sometimes when you're using the word such, it can be ambiguous, especially where there are more than one nouns in that expression. So you have to be very, very careful when you're using so that maybe you follow it closely with a noun so that people can know exactly what you're talking about. Maybe such boys or such, but try to be very, very write up very, very clear. And what I'm saying now might look like a lot of words, but in practical form, when you're drafting, in fact, across all your courses, you're going to be drafting. So that's why I'm saying all of this, so that you can be very careful of what you're going to use. For example, a very good example when you're drafting statement of claim or affidavit in your civil litigation. We are going to use a lot of words. So for example, you are saying that maybe in the question they gave you, they said a company was defrauded by a particular entity called A, and he's trying to say charge that company is trying to charge that person for that particular offense, and he wants to get damages. You know that when you're in instrument of claim, you're taking what happened one by one, starting in the fact that okay, you're explain what the parties are. In your first one, you're saying the first claimant is ABCD, a company is at the social place. Maybe you need a multiple claimants, explain each of them in that breath. Then the next paragraph, you are saying the defendant is company X, blah, 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 blah. And next one, you are saying the claimant says that company X defrauded them. Next line, you probably give more information about the fraud that happened. In the next line, you are saying how because of that fraud, the company wants to sue so they can claim damages. The next line, I'm probably saying that therefore maybe the damages are as follows. Where the claimant claim in this are as follows. You list everything. Imagine that you now use a word like a company called X. You are giving your readers or the judge a very loose room to say, oh, maybe they are different company called company X. Unlike when you say the company X, which is more specific. You get. So that what I'm trying to say is just reiterate the importance of words in your drafts. Also, when you're using such, you might want to, or better when you're drafting, don't use such where there's that, because it might confuse people as to which particular thing you are referring to. Don't use such where you are referring to a noun that was used in that sentence. You must follow it closely with that noun that you intend to refer to. So just also check that your reference is unambiguous. So if you are using such here and there's a noun before it that might take people away from that noun, try to explain it in that word. So maybe for example, you said such boys. In that same breath, it says such males. You know that can very confusing. So your next to that word, maybe using such now, you can say such boys again. So that you are bringing back the data back to the use of boys as against male. That was in that statement. And that word again is and. Usually we usually use and in conjunctive sentence. So maybe you say Feyi and Onyeye. Yeah, like probably linking them together. You're saying that okay. Let me say full example. Feyi and Onyeye went to Ibadan. Now I'm saying Feyi went to Ibadan. Also, Onyeye went to Ibadan. You get. But sometimes some people might use it in a disjunctive way to mean different people. But generally, we use the word more when it's conjunctive. There are several cases that might give more meaning to it. I mean, case laws. But as per now, generally, these are like generalistic principles. So again, I'll go back to the point of saying habits that you should avoid when you are drafting. I explained some earlier. Try not to misuse conjunctive or disjunctive words. For example, be careful you're using and or both. You get when you are drafting so that it will not cause ambiguity. Avoid redundant words. Avoid uncertain pronouns. Avoid abbreviations or acronyms. Not as possible, except you're going to explain what that acronym means. So and a great example is about your exams. Why I say you are saying karma. Your first use of the word karma as in CAMA 2020 cannot be just that word. It must be you've said it in full. Company and Alignment Act 20. Then maybe in bracket now put karma, so that going forward everybody knows that karma means that. Because I can argue as your examiner that karma also means Christ Apostolic Membership Association. What do you say then? Am I correct? Am I not correct? So to avoid that stagnation, you want to be expressed in your words. Are you following me? Are you following me? Yes. Yes. That's what I just explained now. So I said that when you are writing your exam, because for example in corporate law exam, because you know they are going to be using a lot of comma everywhere. You know how long it take you to write comma, you know how long a word is. In your first use of that word in the question, you want to write the full meaning. In brackets, write comma, like CMA near it, 2020 in brackets. Therefore, any boy that sees that knows that you are saying, what any that you use comma, we are referring to company and alignment act. So in your first use of that word in that question, I feel like you write it in full. Do you understand? So that the fact that you wrote comma as in full in question one does not mean that if I it in question two, you now say that no, let me put comma again 2020. No, in that question two, put it again because you know in exam, law school exams, different markers mark your stuff. You get they'll not come and check what you wrote in question one. So in your each question, try to make sure that all those acronyms are in full the first time you're using it, and then make like so. Maybe in the question now I'm saying that it's evidence act, and I wrote EA first. Next line, everybody knows okay, EA means evidence act. So you get so that way I don't have to keep writing evidence act 2020 everywhere or 2011 everywhere. So at least answer your question. Okay, thank you. So I think I've been able to explain some of these basic drafting principles about the word of use of shall. May can be discretionary, it can be mandatory. Ordinarily, you'll say may is discretionary, but many times in law, usually used in a very compulsory manner. Just check the context. Must usually mandatory, both ordinary and legally. Shall depicts command, mandatoriness. But sometimes in limited circumstances it might be discretionary. Or shows disjunctiveness. It's saying if I'm like if I say Ayomide or Feyi, I'm probably saying that it can be Ayomide, it can be Feyi. I'm not saying it is Feyi and Ayomide. Do you get? Usually using this disjunctive, that means separate. Or like and so just make sure that you know this. It shows alternative generally. But sometimes they might want to use it in conjunctive way. But just be very again, like I said before, be very wary of the circumstance of its use. Also, and usually used conjunctively. But legally, usually saying that for each person. Again, look at the context. And if you see I appear like and or, many times this can cause sometimes it can cause ambiguity legally. So you want to be very wary of this kind of because it can both mean conjunctive and disjunctive because they use and or which can be and is conjunctive generally or it is disjunctive. So if people put them together, you're trying to say that in that expression it has dual function. So you want to be very wary so that you not make your sentence ambiguous. It's also subject to is saying that as against the general provision there is a limitation that we're introducing in that context. On that one is when you see notwithstanding. It means despite. It just shows again a kind of limitation. Also, we have in drafts without prejudice. Generally, I are saying that that provision is not meant to adversely affect later uses or provisions. And usually the meaning both legally or literally. Also, when you use proviso, it's like you introducing a qualification, a context. So if I say Ayomide is a girl, except where I say Ayomide, and provided Ayomide is not wearing trousers. Now it means that if Ayomide is wearing trousers, I'm saying Ayomide is what? Something else except being a girl. So the use of proviso in a word kind of introduces a qualification, a context, a separate context, an exception, a limitation. Also, when you use the word except, unless, or save, also you are introducing a limitation. And a particular one that causes a kind of confusion is where I'm going to next. That expression that relates to time. I will list examples of them and I'll now explain. Expression that with time includes use of on or before, not later than, not earlier than, at the expression of, month, and so on and so forth. This one is very common, especially in your property law drafts. In fact, across board. Where you see on, most times it refers, or literally, it refers to the date. For example, if I say on so day, it usually includes that day that you're mentioning at that particular moment. If I say on 21st, I'm probably including on 21st that day. Especially when you're counting time. If I say, a draft that says that Feyi must leave a property on or before 21st of July, it means I'm saying that if you are counting your time, include 21st. Include 21st in your draft. So that is usually included so that it must very wary of this in your exam draft. If I say from, legally speaking, from usually excludes that date I am mentioning. Literally, it might not include, but legally, many times, it usually excludes. Let's say from 21st, it means if you are counting, count from 22nd. Do you understand what I'm saying? Do you understand what I'm saying? So usually that specified date is usually excluded. So I'm saying that your date expires from 21st. Take out the first and count the next time. You get. So let me give you an example. So if I say 21st to 24th, or from 21st. So I'm saying that count from 22nd. So I've already explained when you see on, so that in that time you include that date. Expires on 31st. That means include 31st. So you're counting a 365-day period. Make sure that you include that date. So that you don't count from the next day and not be counting 366 days as in 365 days. But when you see on or before, it usually has similar effects. That specified date is usually mentioned. Example is when I say on or before 24th of June. 24th of June usually included in your date. If I say not later than 24th of June, also I am including 24th of June. Do you understand? You understand? Okay. Yes. You're also including. No, you are including. Yes. I think, yes. So even help you, let me just list a group of words that have similar effects. So when you see the word on or before, not later than, not earlier than, and the expression of, usually those words include the date specified. I'll reiterate. Where you see the word on or before, not later than, not earlier than, at the expiration of, by 24th, by, to 24th, those words include the specified date. Do you understand that breath? But when you now see words like before, after, from, usually excludes that specified date. Do you understand? So that in case you know this one's your exam, you'll not be confused. So I'm trying to group it together so that I'm not confuse you. So those ones that I clarify together now, you understand, Abi. So also where you see they use months, it usually means a clear calendar month. But many times the corresponding day of the next month is included. Let me give an example of that. So if I say that from 23rd of June 2022 to 24th of July 2022. Oh, let me say it again. To explain the corresponding day rule, if I say 23rd of June 2026 to 23rd of July 2026, you know now I've put two days two different months. What I'm trying to say here is that you should include the date of that new month. So it's a 3-day period. I'm probably already including that 3-month period. I'm probably already including that new month that I'm already mentioning, that July in this context. So for if I'm counting 3 months now and I say 25th of March 2022 to June 30th, you get what I mean, Abi? So you're probably including that corresponding day. But where there is no corresponding day now in that month, that last day will expire, you're probably going to use the last day of the month. But let me get out what I want to say. Where there is no corresponding day in the month, which the validity will expire, the last day of that month becomes the corresponding day. For example, why I say June from 31st of March 2022 to 30th of June. Then that June doesn't have 31 days. So that month ends that month. Similar thing that applies for a clear day. If I say a clear day, I'm probably saying 24 hours. You get? That means I'm not saying a fraction of that day. I'm saying the full 24 hours. So it starts at the beginning of a new day and ends the following new night. So if I say two clear days, what do I mean? Yeah, I mean 48 hours. So that means 2 clear days from the date the contract is signed will not change the fact that the time starts running from midnight. So that full day will apply. That full day will apply. So do you understand what I've said now in that context? Okay, thank you. So I think with this I've already explained some common expressions that can come out in your MCQs. I've explained that. So I've just quickly explained components of legal sentences. Sometimes you would see a subject, you see a verb, you see the object. What do I mean? Normally, when you are drafting, you may have a legal subject. That's usually the person that's drafting. Let me explain in words in your draft. So, if you are drafting, that is the who or the what in that expression. Who is doing what? So I'm saying every taxpayer should do ABCD. In that breath, I'm saying that the taxpayer is the what? Subject of my draft. The action is now what I'm saying. What means what the draft man is saying that taxpayer should do. You call that legal action. Oh, all taxpayers must pay their tax. or they must file an annual returns. Anything you want to say at all, there is a what? There is an action, a legal action, what they want you to do, or what you as a draftman want the person to do. So in preparing your draft, the draftman must have a picture of what he wants the legal subject to perform. It can be a mandatory action, it can be prohibitory, it can be permissive. You might say, if you do this, you might say taxpayer must not do this. It means you are prohibiting from something. Or taxpayer must do this. You are mandating him. Also, we also have the description of that legal action. So sometimes when a draftsman is giving a taxpayer a taxpayer an action to do, he might define it to a context. So he's saying, for example, that person should do this through this method. So I'm saying, for example, in a taxpayer context, the taxpayer must file annual returns using ABCD, or file annual returns in so and so dates. Now is describing how he must file annual returns. So let me give an example, and I want to try to break down that example using these three things I've explained so far. If I say, or if a draft book is saying, every citizen has a right to life, and therefore must not be found guilty of murder. Try to explain who is the tax object, who is the tax subject in this case. Who is the tax subject in this case? Let me put the example. Every taxpayer has right to life and therefore must not commit murder. Who is the tax subject? Every citizen. Correct. What is the legal action? Yeah, but I said that I'm talking about the example of what I said. Every citizen has right to life, and should not commit murder. What is the legal action here? Exactly, and you can, in that breath, you can say that I've already described that describe what you meant. You say he has right of life, therefore not commit murder. So you have kind of given a context to it. So I'm just trying to explain those components of legal drafting. And finally, you may also have in that breath conditions. You may also have condition when the draft is saying that these are some actions that you, like, for example, subject to any portion of Common Animal Act. That means that draftman has limited you. And a common one is when you see act I think in conscience they'll say and any further acts of legislative. That means they're telling you that even if this constitution is only one book, we are telling you to avoid your minds to other acts that might be enacted by legislative powers. And so you may also have legal object too. So this is just me explaining some of these things. I've already explained the words. I've explained when you can use when, but, and so on and so forth, and their meanings. So just to reiterate, but usually brings a contrast to that expression, to an earlier statement, because gives a reason, when gives a time or kind of event, except brings limitation, provided gives limitation, however also gives limitation, therefore gives a logical result or outcome, then connects it to something that you have said before. So I said Feyi is a girl, then she's a boy. I'm saying that, okay, and this is a very crazy example anyway, but I'm saying that in that context, then connects both expressions. Maybe a better example will be saying that if all females are women, therefore Feyi is a woman, or Feyi who is a girl is a woman. You can see use of that word in that context. So when you are drafting, so you must also be very wary. I think with this, we've explained to a great extent drafting principles and the importance again. I said that is to bring clarity. So there are different stages in drafting, and I think you will see this on your exam. So maybe I need to reiterate it. There is the taking and understanding instruction phase. Now, before I continue, this part of what I'm saying is different from what I will explain under legislative drafts. So that in case you see your exam, pay attention to that context. So, generally, the stages of drafting, I didn't say legislative, I said of drafting, is number one. I think somebody's mic is unmuted. Please. Don't know. I'm hearing sound. I'm hearing a sound. Okay, I think the sound has gone now. Okay. So I'm saying that the stages of drafts. Are you with me? Okay. Stages of legislative drafting. I'll explain that one very soon. The stage of drafting includes, in fact, there are like there are like 5 stages. So I think this will help you. And maybe you can call it this acronym TADCS. TADCS. What do I mean? T means taking and understanding instruction stage. This is where you're going to get your client's instruction. Oh, what should I do? What should I not do? What is the means of doing that particular thing? You get sufficient information here. The next thing is analyzing the instruction. Here you're now saying, okay, now that you have told me this, what are the potential risks, potential dangers, practicability, what you're telling me, category of people affected, penalty for the breach. Like you're just considering, oh, is there a conflict? Is there a authority? That's your analyzing stage. The third stage is the designing stage. This is where many people actually start to draft. It's the part where you start to do your rough draft, maybe drawing a picture, what you are doing. So the designing stage is typically you outlining the structure of what you want to write. So for example, if you're drafting a bill, you are saying, okay, the bill should have a chapter, it should have parts, it should have sections, it should have subsections, it should have paragraphs, it should have subparagraphs, it should have subparagraphs. It's basically you just explaining what you mean or what the outline that you want your draft to follow. The next one is the composition stage. See, that's the actual draft. So you have left the realm of outline now to actual drafting. This involves the preparation. In case of a bill, for example, it's where you're now saying, okay, let me now fleshing up what I've already prescribed in my earlier outline. And again, this is where the earlier comes in. Try and use simple words. Try not to use redundant words. Try and be consistent in your expressions. Try and use clear languages. Try and maintain order and coherency so that people can really understand. And here, for example, you're drafting a bill. This is where the doctor that she use precedents. So precedents is usually very recommended in this particular stage. And finally, we have the scrutiny stage. The scrutiny stage. This is where you're taking another look at your drafts. So it usually includes asking maybe a professional colleague to look at your draft, to make a review, to make inputs, to do final check, proofreading of that draft. So that it can be error free. You now say, okay, let me cross-reference, put punctuation, check my spellings, my numberings, and so on and so forth. So do you understand the stages now of drafting? So it's similar but not the same, because the question will determine all of these things. Your question, about share now. Some of them they have 3, they have 4, they have 5. So be very careful of what the question is asking you. You get, you have to be careful because those are like models. Those are like models. Let me see if I can touch on it a little bit before I come back to what I'm explaining to you here. Maybe to help you to give a little more context to what I'm explaining. Trying to find that's not in our scope for today, but I'm trying to see if I can touch it. Trying to let me see if I'll find that bit in how I'm teaching you. Let me see. I'm not sure. Okay, just give me a minute. Give me a minute. Let me see. Okay. So usually Avon share is usually applicable in client interview. Please mute your mic. Please mute your mic. Are you with me, Faye? Are you with me, Faye? Faye, are you with me? Are you with me, Faye? So I can explain what you asked for. Faye, are you listening to me? Okay. So I'll quickly explain Avon share principle and co. This is usually Avon share is different from drafting from drafting principles. Avon share principle usually is under your client interview topic. So that don't mix them up. So Avon share is typically under definition of stages of client interview. Avon share has 3 stages. Oh, it has listening, questioning, advising. It's not it's maybe when you're explaining that drafting principle, you might want to use that logic, but it's not the same. It is for client interview. Also, under that client interview, we also have Mike Wolf. He has 5 stages. His own is number 1, listen to clients. Number 2, analysis of facts. Number 3, investigation of facts. Number 4, taking decisions on course of action. Number 5, implementation of decision taking. You also have Clay and Smith, which also have 7 stages. You also have Brian and Grimes, who have 7 stages. These their own stages are usually important in taking interview, in doing interview. And if you want to link it to my explanation of drafting stage, it might probably fall under the first stage where I talked about taking, analyzing instruction. Understanding from your clients. You understand? But typically, those principles are limited to you taking client interview, so that and the motive here is so that you can practically understand what your client is giving you, the problem that he wants you to solve. You understand your client's issues and to see, okay, what are the applicable frameworks and then the legal issues that you can do from his facts. But in drafting, it's a bit more it's more elaborate. It goes further than just client stage. In drafting, I've said that there are 5 stages. There's taking instruction stages, analyzing this, and so on and so forth. But for drafting, for example, when you're drafting, you can use it logic, but the context of saying what I want to draft. What is the motive of me drafting? What do I intend to solve? If it's a client person you're trying to draft, for example, you're saying that, okay, you understand what the client is telling you to do. Understand the principal object, the background, the means of achieving. So, but you know that drafting goes beyond just client processes. It goes even far as drafting processes. But you can use that knowledge base to help you. So back what I'm explaining. Wait. Do you understand what I've said so far? Do you understand? Do you understand? So that don't mix up that one in your exam. Avon share and co is for client interview. Stage of drafting is different. So I think with this I've explained the stages of drafting. So do you understand the stage of drafting? Okay. Welcome, Nofisat. So we are explaining the stages of drafting, and so on and so forth. So I'll just quickly go to the next part Hopefully, we'll try and make a record available so that maybe you can catch up on what you've missed out on today. But anyway, I'll just continue. I already told you the importance of drafting and what you should take note of. Make sure that what you're drafting covers your client's instruction. That you have that's an order. It's accurate. It's precise. Legal language. You probably use form and procedure when you're drafting. They should take note of your schedules, definition, interpretation, and so on and so forth. So I think this brings us to the end of drafting principles. Then we can go into legal research. So again, those concepts they go hand in hand, because when you are conducting legal research, or when you are drafting, in fact, it's good that you conduct research so that what you come up with can be very holistic. And this is just me explaining the importance of legal research. It's a core skill that every lawyer usually have. In fact, when you look at most of the draft now are CVs, most of the, or maybe on your LinkedIn, and they ask about your skill set, many people probably write, "Oh, my skill set is I'm very good in drafting, in legal research, I have high drafting skills, and so on and so forth." Basically, what this underscores the importance of legal research to the lawyer. A lawyer that cannot do legal research is as good as a bricklayer, because what do you mean by you cannot do legal research? Legal research gives you in-depth understanding of what you intend to delve into, so that you will not be writing from a limited scope. So in legal research, you probably very good with your tools are your library, legal research like maybe say Law Pavilion, NWLR, textbooks, articles, publications, and so on and so forth, so that you can understand what you're writing. And when you're doing legal research, you're combining your knowledge, your skills, and your value. What do I mean? Knowledge, you're looking at, okay, what do I understand by the body of law, or this area of law? Your skill set as a lawyer, you've been trained. That's what law school is about. You're not trying to say, okay, how can I apply this knowledge to legal problems? And then values, your ethics of a profession. Or as even if I'm trying to solve my client problem and do a good legal research, okay, how can I ensure that I don't flaunt the RPC, or basically those things when you are drafting. So what are the functions of legal research? It helps you to appreciate the current position of law. It helps you to discover legal authorities in a case. This is what I'm saying to you now, and it's very simple, but it may come out to your exam. So when you understand it, you can easily give them where they ask you. It also helps you to identify relevant case law that you can use, or statutes, or applicable cases in that particular area of law that can help you in enriching or fleshing up your draft. It helps you also to find a theoretical basis as to why you are drafting something, a particular applicable case. For example, if I'm doing a draft on or I'm conducting a research on let's say receivership. If I go and read maybe Badmore's book on receivership, I read maybe Ewaoluwa on his book, or someone's book on leadership. For instance, I will have very, very great knowledge, and I'm gonna back it up with reading Law Pavilion and NWL. I see decided cases, even recent ones. What do you think will happen to my write-up? It's very rich, Abby, and I'll find cogent areas of law that are, that will help people know that, okay, what I'm saying is an authority that backs me up. Also, legal research helps you to establish a fact they are saying. So if I say that, Faye is a good girl in my legal research, another person was saying that, Faye in so and so case, it was said that Faye was the one that saved a community from flood. What am I doing? I'm bringing cases that solidify my claim. I'm not just talking that Faye is a good girl from nowhere. I'm saying it because I know that they are authorities to establish my point of view. Also, it's also very good in helping you to prepare for trial or for ADR, to formulate your trial plan or your case theories. You also have to map out your line of action that you need to take, so that in case maybe you are saying that, I want to take this particular view. When you do research, you're like, okay, no, let me add this and this more, because I cannot take particular view, because I've seen more information that will not make my intended view to be, to be correct or apt, so to speak. Also, There are many aspects of legal research. It could be manual, it could be electronic. Just to put that in use. You can research fact-wise, you can research law-wise. By fact-wise, I mean when you interview, for example, if you interview your clients, you're trying to get facts out of them by from their oral evidence, from the document that they also give you, maybe receipts, contract agreement they give you. You can also take out facts from there. And also when you examine physical objects, maybe for example in a crime scene, you see a knife that has blood. These are research as to facts. But when it comes to research as to law, you're probably looking at case laws, textbooks, substantive law. This is where your professional skills comes in. So there are also broad categories of research work where you look at, let me say, domestic, international law, Nigerian statutes, foreign English law, English law, customary law, and so on and so forth. Do you understand what I'm saying so far? Do you understand what I'm saying so far, Faye? Okay. So with this, I think you understand now why you do legal research, the function of legal research, and then the aspects of legal research. So I'll now continue into sources of materials. So we have primary, we have secondary, and we have tertiary. And this is why all I'm saying this is because we have different sources of research. Some of them have more weight than the others. The primary one, for example, has more weight. And usually generated from before I start talking about the weight, let me explain. Primary source of law is generated usually by government bodies. So when you look at statutes, case laws that the court gives, regulations, bylaws, rules, guidelines, law reports, NWLR, and so forth, they are usually government made. But and again, back to the effect, they're usually mandatory and binding. For example, when you look at case law, also, if you look at the hierarchy of court, also comes into play. If you look at if you look at the decision of federal high court as against Supreme Court, which one do you think has more weight? Which one do you think has more weight? Which one? If you look at a case law that federal high court gave court of appeal as against the one by Supreme Court, the Supreme Court one has more weight. Let me just say that to avoid wasting more time. So basically, you can take also, if you are looking at hierarchy of case laws, you want to look at the court also that gave that decision. Also, to proceed, we also have secondary sources of material. This one are usually not by government. They are not usually government made. Yes? What? Okay, so I'll proceed. We also have secondary. Usually doesn't come from government made laws. Usually comes from looking at textbooks, articles, and usually persuasive in effect and not binding in effect. They're not usually binding in effect. Okay, so I'll just do a roundup of what I was teaching earlier in prophetics. So today in prophetics, the topic is typically drafting principles, legal research, and closing of files. I already explained what the drafting principles are and legal research. So to round off that particular discourse, I will now take us through. I was speaking about legal research, and I already spoke about the what legal research means, the functions, the aspects, and I was on sources of material before I stopped. So just to reiterate, legal research is typically a part of our work as lawyers, wherein we make in-depth findings to support any facts that we are raising. Are you following me?
Yes, ma'am.
Yes, or any facts that we are relying on. So usually a blend of three things: our knowledge, our skills, and values. So I already explained that knowledge is what you're getting now, what you're reading in law school, your notes, your university, those are knowledge. But the skills come in where you are now trying to apply that knowledge to real life situations. So it's one thing to know legal principles, like, okay, there's a tax law that says A, B, C, D, and E, F, and G, H. But there's even more when you try to apply these principles into real life scenarios. That's where it makes sense. But even more is where that in your application of these principles, you try not to go out of your ethical expectations. This is where value comes in. So as long as even in your practicing, you're expected to have a boundary. That's why we have RPC there to guide us on this as lawyers. And I gave a list of functions that legal research has for lawyers. And I think this one is something that we can even say without me saying in your note. Why do you do legal research? Because why? You want to deepen your knowledge about something. You want to make more findings. But just list for some of them is to be, it's to be acquainted with the comprehension of law. It's to discover legal authorities in a case. So identify relevant case laws, statutes applicable to a particular case or matter they are dealing. Is to find the theoretical basis where you're making an assertion or the applicable principle to an assertion you're trying to make. So for example, you're saying all law students are expected to wear white and black. If you just say this without be conducting research, you may just be like you're just saying something that's ungrounded. But when you now say, okay, in the code of conduct for law students, they specifically wrote that they should wear white and black. It then makes more sense because it's something we are relying on. But how will you find out if you don't research? So that's what legal research does for us, even as lawyers. And it's a skill that we cannot do without in legal practice. Also, another is importance for legal research or function that it performs is typically on an importance. Every comes to your exam, whether it's a function or important, that is one and the same thing. It helps you to prepare your case strategy. It helps you to know the path that you want to chart in that action, so that to define how you want to take your action. It helps the lawyer to to think on his feet, to raise questions or respond to objections holistically. It really grounds you typically. It helps you to determine the offense if it is known to law. So example, I say that if for example I'm in Lagos and I say that somebody married two wives. In some states it's not wrong to marry two wives. But if you're in Lagos, they might probably fault you for bigamy. You get because Lagos has a law called bigamy. But in a place where there's nothing like that, can I hold you liable? Even if in court it's an offense, can I hold you liable? I can't. And I think the classical case for that kind of example is Alcoa and Fagbolade, when they say that you cannot hold a person for an offense that's unknown to law. But anyway, what am I saying? You only find out this when you conduct legal research. But sometimes something that we think are offenses or are big things are not. But when you conduct research, you can actually confirm a provision of law. So you can confirm, you can do legal research, be it manually or electronically, using your library, using resources like Law Pavilion, NWLR, and so forth and so on. Am I too fast, or are you get what I'm trying to say?
Yes, I'm listening to you, ma.
Okay. So I now give another aspect. I said that okay, beyond the meaning and importance of legal research, we also have aspects of legal research, and I mentioned that we have research into facts. We have research into law. For research into facts, you can get this when you interview a client. They tell you, oh, so you see, I entered into this transaction with you for Fagbolade. Transaction we both agreed A, B, C, D, E, F, G. She even paid her 15 million naira and said that she was going to do this. But no, she breached the contract and now, yeah, if that the layer can have research through what the client is telling him. That way, you'll be able to examine documents, agreements, and documentary evidence. And another way is even when you are doing for real evidence. So if you're in a crime scene, for example, I think I explained it earlier. In a crime scene, and it is like, let's say there is maybe they say that there's somebody committed suicide, but in a crime scene you are seeing knife that has blood at a distance from the deceased, a very far distance, and you are seeing blood splatters, maybe in the toilet in the bathroom, and apparently the person was supposed to be hung in the parlor. You know that from this you can start painting or deducing evidence that okay, if we say this is suicide, why is there this? Why is there that? To be sure if it's really murder. These are ways of conducting research. Examination of physical objects. When it comes to research into law, the name is telling. It means you are checking fact based on legal category, like substantive law. Maybe at the academic stage, where you're looking at contract, fraud, criminal law, matrimonial consent, so on and so forth. But in the professional stage, you're probably looking at procedural law, like civil or criminal law. Anyway, there's a lot of things, but those are really telling. And then you can also check fact. You can also classify facts in source of law. Maybe when you look through, that there are a body of research that you can look at from the receiving English perspective, e.g., Rules Act, or the Nigerian statutes like the Constitution, Evidence Act, and so on and so forth, or case law when you're going to look at law reports like NWLR, FWLR, law pavilion, and so on and so forth. That's electronic form, or customary law. Here, having said this, we also have sources of materials that you can use for legal research. One important thing to know is that based on your source, some have more authority than the other. I will throw a teaser now before I explain. Which one do you think has more weight in law? Or which one do you think is more mandatory than persuasive in these sources? Primary, secondary, and tertiary. Which one do you think has more weight?
Primary sources have more weight, ma.
Okay, which one is the least weighted out of the three?
Tertiary sources.
Exactly. So I'm saying to say that primary sources are usually the ones that are generated by the government. What do I mean? Like statutes, for example, ACG, or there's probably like a legislative house sitting down somewhere deciding on those, basically government made law. We have constitution, we have evidence act, we have a lot of laws like that. We also have rules, we have case laws, we have regulations, we have bylaws, we have law reports. But basically the thing that I should know there is that it is what government made, and it's really like you just said, it's mandatory and binding. For case law now, on its own aspect, because of in fact, I think it still applies to um started, but I'll start with case law. Case law now, there's also a something called hierarchy. All of cases are binding, but it's also an hierarchy depending on the court that made it. So what happens where a court, like Supreme Court, makes a decision, and then there's a contrary decision by the Federal High Court? Which one takes precedence in two of them?
The Supreme Court decision takes precedence.
Exactly. That's because of the hierarchy of courts in that particular situation. So those are things that you want to take into when you are looking into hierarchy of courts. But going forward, we also have secondary sources of law, where you say that this one is usually made by government, usually made by certain private individuals. There's usually an analysis of legal principles or problems by learned authors or commentaries by experts. So, for example, if I wake up tomorrow and write a textbook, and maybe what I wrote is quite instrumental in what I'm saying, if you're going to pick that during your legal research, you classify it as what? As what? Try your hands on it. What do you think you classify it as?
Secondary source, ma.
Exactly, because it's something that is not from government, for example. But this is even, I'll explain more on this when I go to share, because that one also it's not really by government. But what effect you think it has? It's usually persuasive. It's usually persuasive. That's for second sources of law, and it's not usually binding. But the importance is that it provides guidance, which one can follow through when you are trying to like establish a position of law. Going forward, also have tertiary. Tertiary provides info most times on how to locate primary or secondary sources of law, which must have been identified. So now, are you getting the difference now?
Yes, ma'am.
So example of this is usually index of cases, journals, Wikipedia. laziness and all those things. But usually they are not to be cited in court at all. You can also refer to them as finding tools. Most times they just refer you to those sources of law they are trying to find. Not that they are in themselves of any effect at all. So now with this, I think you understand what it means to when I say primary, secondary, and tertiary. Do you? Before I continue.
Mama, I do know.
Okay.
Yes, ma'am.
Yes. Thank you. So I'm just saying this to just give you so that you know me miss out completely on the um earlier part of what I thought in the second session. Before, because I want to just try and give an holistic class before I now go into the entire the different course outline. So anyway, what are the hints for legal research? Things that can help me in making legal research. A lawyer should have good library. It's very important, or at least have an e-library. And you might also know when you are doing um your library or law office management in prophetics. I think that's an earlier course. I don't know if you did that during before externship or if you know that at all. But you will find that they how to talk about library. Also, lawyers should possess dictionaries and other materials that can help you in making effective research. Make notes when you are researching, so that everything will be in your head. So, yeah, so they can have something like have a reference point to after all your research. Make photocopies when you need them. Get an efficient research assistant when necessary. Consult colleagues also. Speaking to your colleagues is also another way of conducting research. Um, but also be ready to contribute when colleagues ask you questions. So it's semantic stuff. So much is given, much expected. Also, we also have you can also talk to court officials. They're also very good when you need some, especially when it comes to court issues. So I think with this I've explained sufficiently what I talked about. That's the second lap of this topic in politics, which is legal research. Finally, for today, I'll talk about opening and closing of files. But I'll give you one extra thing which I promised at the earlier time. That's some minutes ago, which is on legislative drafting. So I'll just give you that before I go into corporate law. So that is that because I'm not sure that I'll talk about it again because of your before you resume. But I'll just teach you because something that comes out in your exam. So quickly, I'll just go into this one. This one's quite short. Opening and closing of files. So most of the time when you have clients, you open file for them. I'll make it as direct as possible. Are you following me?
Yes, I'm following you, ma'am.
Yes. So if any person don't understand, please let me know so I can come back. So when you have a client, they come to you,
All right, ma'am.
favor, I have a particular issue, and I want you to help me solve my issue. What should I a lawyer? You open a file for them. That will be their own unique case file. So law firms usually open this to handle the case when they are briefed. And if I look, that kind of file contains file number, passport of the client, and then per client you should have a case file where you got their name, their address, their contact information, their occupation, the date the file is opened, the name of the court, if it's a court issue, what is a transnational issue. Also make that very express. So just to name me, I'm talking about opening and closing of files on our prophetics. I hope you learn. So you also when you open file for your clients, you in that sheet in that case file put all the things that like the client instruction. Okay, can you hear me clearly now? You say my line is breaking. Can you hear me clearly?
Yes, ma'am, but I didn't hear what you said very quickly.
Oh, I was talking about no, I noticed that I just joined. So I was saying I'm on opening and closing of files. Okay. So I said that when clients come in, you open their file for them. Usually it's actually unique to each client that you have. And those files have the names of the client, the package of the client, maybe their contact information, their address, contact information, and all kind of information. Maybe even the professional engagement that people have, where you have their fee notes, the price you are engaging them for. And then this kind of file is something that you update as the case progresses. But one thing that you should also notice that for every instruction that your client gives you, try and put it in writing to avoid, because no client can verify and they'll tell you, oh, I said you shouldn't do this, but you did it. But when you have it in writing, they cannot come and now deny that position later on. That's what having a file does for you. And then there are different kind of filing systems. At least there are four of them. Let me give you an acronym I can help you remember. We call it TANG. So you can have it in a topical order. Maybe all these matters are contract based, or they are criminal based, or they are data privacy related, or they're cyber crime related. Just you can arrange your file in that order. That's topical arrangement. You can also have it in alphabetical order, from F to A to G, A B C D. Like that. You can also have your arrange your file like that, with per name of the client. Also have numerical order. Maybe the year that they came into your office, 2021, 2022, and like that. And that makes it easy for you to access later on. And finally, geographical. Maybe the location, maybe one is in Lagos, one is in Port Harcourt, one is in Ibadan, one is in Ilorin. Those are filing systems. Again, we have topical order, we have alphabetical order, we have numerical order, and we have geographical order, or any other order that you create in your office that makes it easy for you. Some people use reference numbers, but in as much as you open files for a client, there'll be a point where you have to close that file. This is a very, very important aspect. I think you should pay attention to, because they're really very examining, be it in your theory or in your MCQs. So what should you pay attention to when you are closing a client's files? Check the fees. Have they paid the fees? Have they balanced you? Check who's supposed to have the custody of the file. So are you returning anything to them? Are you returning it for a particular period? The right to keep written documents and photocopies usually remains with the client. Sometimes lawyers can be able to hold it for some period. I think about 7 to 6 years period before they now ask you to take it off completely from a database. Are you following me?
Yes, ma'am.
Okay. And then there's also a length of period for keeping those files. And finally, self-assessment and audit. And you look at, okay, what have you done in that file so far? Maybe progress reports, and if you're not any outstanding for that particular client as you are closing their file in your law firm. So again, the act of closing the file is done when a case is concluded or it has ended in your own end. Sometimes it can end maybe naturally where the case actually comes to its conclusive stop, or it can end when a client disengages you, or it can end when it's dealing with a particular transaction. So if you are done that transaction and you may want to end. So typically explains um, the act of closing a file. So or sometimes also the client's personal file is when you can open. Maybe person is a retainer, and it now what terminates your contract. You might want to close their file, but generally it remains open until that case file is closed. So most time when a client closes his file, most time they draw two parallel lines across the face of that file and they write closed inside it. That's the practice, writing, drawing two parallel lines and then closing it. So after you are done, you can now tie the file and keep it as you please. I mean, your shelf or in the cabinet or on an archive. Many people keep in archives, showing they're done with those kind of files. And that happens in maybe say, and then some law firms have a practice of having like a register of closed cases that they are done with. So also, and I think you'll see this is the next part, the fees. So I'm explaining those things I highlighted earlier. When it comes to the fees, every worker is entitled to his pay. So lawyers are also entitled to their pay. I think the RPC also talks about this. I said that the lawyer is entitled to his fees. That when the RPC even says that if you are a lawyer taking over a particular case from a client, make sure that client has paid the previous lawyer. So lawyers should also request their fee, and you can do this through a letter to your client, tell them that okay, I'm done with your listing, pay your outstanding fees or demand your legal charges when you have outstanding ones. And then you give your bill of charge and maybe a receipt where the payment has been made. Do you understand this part? No.
Yes,
Do you understand? Okay, so going forward, we also have custodial documents like I added earlier. So generally, a client, the documents are part of the client, and you have to give him whether he asks for it or not. But in practice, lawyers usually retain those files where they need, especially where the need arises. But the original ones are actually returned and acknowledgement copies obtained and retained by the lawyer. However, it's good practice for the lawyer to make and retain photocopies and then so that at least if anything happens, it's not totally lost. But most times, it's generally a time frame. Like I said before, sometimes some people keep it for 6 years before it's complete deal with your they close the file completely. Also, you also have a length. Now, this is what I was just saying earlier. A length of period for keeping closed files. Status wise, there is no prescribed period before you can destroy a file. However, many times because of your storage facility in your firm, sometimes you don't want to just keep files lying down idly. Many people would suggest maybe a 1 year period, or at least a 1 year period before you um throw out a file. But anyway, the time is usually like a reasonable time. After which you can destroy the file by shredding it or by burning it. But some files may be worth keeping. However, you must note that original files and documents are not to be destroyed. So finally, you also have the self-assessment and audit, like I said earlier. It's not common, but it's a good practice. Yeah, you just maybe you can send a questionnaire to your client and say, okay, how did you do with this file? Are you like, what have we done? What details do you need? Then you ask your client questions that will help, maybe even improve your practice as a lawyer in the future. So, do you understand this part for opening and closing of files? Or do you have any questions that you want me to deal with?
I understand you, ma. Thank you very much.
Okay. So I'll now quickly go to what I promised you earlier. It's not our topic for today, but I just thought that you would gain from it. Legislative drafting. That's what I'll talk about now. It really comes out in exams quite a lot. I'll try to rush through so that we can actually go to the next class, which is corporate law. Because that one is another topic entirely. But anyway, I explained this a bit when I was talking about drafting. And then drafting is when you are penning down client instruction. But when it comes down to legislative drafting, this is done by usually by legislative house, be it House of Assembly, Senate, House of Rep. Usually, what's the name of legislative drafting? Usually, a process through which the instruction of the sponsor of a bill is written down in form of a bill, and it usually like mirrors their intention and that instruction as much as possible in a legal format. So a bill is a proposed law. Proposed law. And one thing I should know is that legislative drafting is not the same as legislative process. I don't know if you get what I mean. Know that there's a person in the house who tell you that oh you must do this particular stage and that stage and this one stage and that one stage. It's actually different from legislative drafting. Legislative drafting is strictly legislative drafting. How to draft a bill. While legislative process is the business of legislation. I don't know if you get what I mean. Do you understand?
Yes, I understand, ma.
Uh-huh. Okay. So unlike legislative drafting, for legislative process, the end result is that it's a law. But for legislative drafting, there's like some processes. It's like I don't how do I put it? Legislative process is like okay, when someone proposes a bill, the house will sit on it. The person maybe first reading, second reading, and kind of what have you. For drafting now, it is you talking about, okay, the you're analyzing the, you're taking down instruction, analyzing the instruction, designing the bill, then the composition of this, and then the scrutiny of the draft. I think I explained this very well when I was talking about drafting earlier today. So maybe you can catch up on this in a call, or just to help you. The stage of legislative drafting is typically taking of instruction. What is the draftman or the person trying to arrive at? You take a stand instruction. Next, you analyze that instruction to ensure that you got all what they meant. Maybe you look at, okay, what area of law is it really dealing with? What existing are there? What limitations are there? You look at it very well critically. And the next is not like you design the bill. By designing now, you've not gone to, like, it's like a first stage of drafting, wherein you have your outline. You're like, okay, I want to have beginning, the end, any I want to put to you have your outline. The final, and that one now you now start your the next stage now is now composition, where you now do your drafting. I'll reiterate. We have taking understanding instruction stage, we have analyzing the instruction stage, we have designing the build stage, we have composition stage, and then we have scrutiny. Scrutiny of the bill is a phase of the draft, is where you're done with your drafts now. You're trying to proofread, trying to review, trying to cross reference so that you have an error free draft. With this said, I'll now go to the principles of legislative drafting. Try not to use unfamiliar words. In fact, I explained this again earlier today, and I think when I share the voice note, you should usually take your time to hear the voice notes so that you will see some things that I may not be able to go into in details now, that I already went into detail earlier today. So,
All right.
yes, thank you. It's not a show of intellect when you're using some jargons, because it's only you that already. How can you be writing a bill where to interpret the bill? They have to come and call a lawyer every time. No, I'm not possible, but write a bill that everybody can easily understand, regardless of the level of education. So try not to use unfamiliar words or phrases like portion to, in toto, pad. Like, just use simple and people can really understand. Avoid excessive or intricate expressions. Avoid inconsistency. So, for example, if I'm saying buyer, I cannot come and saying vendor. Just use one so that people not be confused. You get. Um. Also, try to use plain. Avoid using like legal pairs like null and void and no effect. They are saying the same thing, except where it's like totally necessary. And that one where you say, I add and receive, like just use simple things so that you not confuse the readers. Then also don't use passive languages, use active voices. What do I mean? Like, act as though you prepare the drafts. Not that you're talking in a third person pronoun. Like, oh, somebody like the B, like the example is like you saying the bill was prepared by a draftsman, and you now saying the draftman prepared the bill. One of them is active voice. So you use something like the bill prepared by the draft. That one is more authoritative. But I'm not going to say use active voices. Don't use passive. In law we have something like talk about hearsay evidence. You don't be drafting where your draft and look like as if you're saying hearsay. So use active voices. For example, you see in the question that every citizen has right to life. Now imagine that the question is saying something like, how would I even put it? When the question says something like the um citizens have the right to life, to do ABCD, but one is not as authoritative, but one is saying everybody has right of life. It's simple and clear, and it's very like express and commanding. When I drafting to try to use passive voices. Avoid archaic words like here and after, said vendor, witness it, where, like just listen simple taboo can understand. Avoid unnecessary use of Latin words like inter alim, imprimateria, sine die. Those can confuse people. I know you don't phrases that are ambiguous. So now I've explained the meaning of legal drafting. I've explained the difference between legal drafting and legislative process. I've told you the stage of legal drafting, and I've now explained the principles by telling you what to avoid. The quality of a good draftsman is usually how you are able to capture adequately the instruction and intention of the sponsor of that bill. How you are able to use proper words and grammar. How you are able to creatively, demonstrate your skill in how you write. Use relevant and even use existing precedents. So your draftsman must be patient. It must be brief and concise and precise. You must show hard work and must have sound knowledge of principle of law. So now I think I'll now go back to the main part that really comes out a lot in your exam. So I'll just list them in a particular order. We have, okay, let me start with this one before I proceed. Okay. So we have the arrangement of a bill, legally drafting. Most times, article outline, bills are drafted in that way as an outline. We have the chapters, the parts, the sections, subsection, paragraph, subparagraph. And I'm sure you have noticed it in the constitution, Abby.
Yes, that I have.
Yes, so that's also something very important. And for chapters, you might see something like they're written in capital letter. You like chapter one. But for sections, it's actually written in sorry, chapters and parts are actually written in capital Roman numerals. And then sections and subsections are actually written in Arabic numerals without brackets. If you look at constitution, you can see this one there. But for subsection, it's actually written in bracket. That's how you see section 6 in bracket 5. What are they trying to tell you? They're saying that okay, section 5 is a subsection of 5. Then you also have paragraph and subparagraphs where they write a paragraph, they write it in small letter. Then subparagraph, they write it in small letter in Roman numeral. Maybe like for example, section 3, section 6, paragraph E in bracket. That paragraph E is the alphabet. That's why I know that it's a paragraph. So if you see an expression like this, section 6 in brackets, section 6 in bracket now you have 3, in bracket now you have E. Which one do you think is the paragraph? Is it E or 6?
It will be the paragraph.
Exactly. So you understand what I'm going to say. So for sub paragraph, the way write it in small letter Roman numeral after the paragraph. So after E now, they can now write in brackets VI. But also we have sub paragraph. So you have paragraph in one breath as E. You now have sub paragraph as VI. After VI is now the sub paragraph. That's the capital letter alphabet. So also we also have heading and subheading. Most times they got heading in bold letters. They don't got subheading in italics. They also have marginal note that if you go back to after this class, go back to your constitution and go and check stuff we have understanding. You see that sometimes they have marginal notes to explain the body of that particular law or to give you a context of what they're trying to write. And I think you can see this even in the current tax law. You'll see some things, or even the constitution, you see at the side, marginal notes. They're able to, they're not part of the law, but they're able to explain what is in the law. We also have some punctuation marks and they use for some clauses like um doctrine clauses, they write maybe a colon. In many clauses they give you semicolon and so forth and so forth. So now let me now tell you the segment of a legislation. Are you following? Am I too
Yes,
fast? Do you
ma'am.
understand? Should I explain the other part again?
No, you're not too fast, ma'am.
Okay, thank you. So now I'll explain again the meaning, the stages of drafting, the principle of legal drafting. I've explained to you the arrangements. Now I want to now go to segment of a legislation. So we have four broad segments. We have the preliminary part, we have the principal part, we have the miscellaneous part, and we have the final segment. So you can call it segment or part, anyone you like, they're the same thing. So we have four. Number one, we have preliminary segment or part. We have principal segment or part, aka substantive. We also have miscellaneous part and we have final part. So now, each of these segments now have their subs or their so under preliminary segments, we have long title, preamble, short title, enacting formula, applications of commencement and interpretation. So if you read your book, you might see more of these things. And to I want to explain that when you read your book, these are very easy to understand. So also we have principal part. This is like the substantive part of your draft of that legislation. Then we also have miscellaneous where you have let me give examples of what's under principal part. We have establishment clause and arbitration provision. This is just two things: establishment clause and administrative provisions. So you have more things under preliminary part than you have under principal part. So also we now have third segment, that's a miscellaneous segment, where you have offences and penalties, miscellaneous and supplementary provisions, part to make subsidiary clauses. So this one is it's not as much. It's like also three elements too. Number one, offences and penalties. Number two, miscellaneous and supplementary provisions. Then number three, power to make subsidiary legislations. Then finally, final part, you have about 6 elements here. You have saving clause, repeal clause, transitional provisions, schedule, citation, and explanatory notes. So I'll now go forward. So I said under preliminary. Okay, wait. If I continue, do you understand what I just said? Or is it a lot of? Am I saying a lot of words?
Maybe a lot of words. I'm trying to follow as you're saying.
Okay. So if I want to slow down, just let me know. So I want to take them bit by bit now. From the first segment, I said that we have preliminary segment. Number one, under it we have. Let me give you a short form so that in case it's exam, it not bore you out. I call this the formula LAPS DIC. LAPS as in LAPSE DIC. LAPS DIC. LAPS as in LAPSE LAPS and then DIC DIC. That's about 8 elements. So I'll take it one by one. L for long title, A for application, P for preamble, S for short title, E for enacting formula, D for duration, I for interpretation, C for commencement. So there's a lot of things, but if you have this formula now, you easily remember. Let me just give formula for all of them so you can remember. So I say number one, LAPS DIC. L stands for what? Can you try?
Long title.
A stands for what?
Application.
Good. P stands for what?
Preamble.
Good. S stands for what?
Short title.
Smart. E stands for what?
That's the last part.
But you tried.
Was it enacting clause? I'm not sure.
You enacting formula. You got why you tried now? Because the first time you hear it, you're already cashing it that fast. I'm impressed. Yes, it means enacting formula. Can you try for D?
Okay.
Duration. Is duration. I is interpretation. And then C is commencement. Yes. So I'm only saying this because I don't want it to get lost in between. Yes. So for the second part, I said that one has only 2 elements. That's a principal segment. So it has just establishment clause and administrative provision. Yeah. So that in case in your exam they tell you draft the principal segment, you're not asking what they mean. You tell when you know the sub elements. Or if they ask you your MCQ, which one belongs to the principal part or this thing, you know exactly what they're talking about. They said that miscellaneous part has 3. MOP, mob. So M stands for miscellaneous and supplementary provision. O stands for offenses and penalties. Again, M stands for miscellaneous and supplementary provisions. O stands for offenses and penalties. And then P stands for power to make subsidiary. So they can more than this. But these are something that you can easily for this if you remember three of this, you can imagine how far you've already gone. And finally, I talked about fast segment. I said that this one has about 6 elements. You can call it the STRESC. 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 S stands for saving. And T stands for transitional provision. R stands for repeal. E stands for explanatory notes. S stands for schedule and C stands for citation. So if you try again together, S stands for what? On that final part.
Savings.
T stands for what?
Transitional provisions.
Good. R stands for what?
Repeal.
Good. E stands for what?
Explanatory notes.
S stands for what?
Schedule.
And C stands for what?
Citation.
You see? Even without saying much, you already understand. So if I'm explaining that, it's very easy. So I'm not going to the explanation. Under long title, it states the general purpose of the status. So example of this is where you say a bill for an act, and or you can say a bill for a law, and for related matters, and from or you say okay, let me put it this way: the beginning can either be a bill for an act or a bill for a law, depending on what you are drafting, and then the end will not be and for related matters or and for matters connected herewith or and for purposes connected herewith or and for connected matters. So the beginning is what? A B for an act, if it's an act. A B for a law, if it's for yes. And then the ending is what? And for related matters. Anyone remember here? Anyone remember out of these four options? For preamble clause now, if you look at constitution, you see it there. So after classical and check. Usually use this one instead of long title to explain the reason for a particular legislation. It is usually used where the subject matter is to remedy exceptional local problems. I don't have an example here with me today, but if you go through your constitution, you will see it there. You will see it there. Usually use it like if you look at constitution, for example, we were in military regime before we became democratic. They said something about we the people, that preamble. If you look at the UN treaties, you also see preambles there. So I think you should go there after today's class. So they usually use it where someone has a remedy national local problem, maybe in decrease or edicts by military regime or national treaty. You see this preamble clauses there. So next is short title. Usually like a nickname, statutory nickname. So for example, now maybe this particular law is maybe let me give you a full law. Maybe the law is about maybe I'm seeing a particular provision, a particular bill, and they wrote the bill for the People Republic of Nigeria for the extradition of bandits. No, that is very long. To make it easier for me, I can call it Nigeria. The Nigerian. I can if I'm just my short title now, I'll probably write this law may be cited as the Nigerian law to extradite bandits 2021. Do you get?
Yes.
So it's like a statutory nickname. So let me give you another example. If you have a law that says this, give me a sample nickname. The Lagos State Civil Servants and Public Professionals Disciplinary Act or law, sorry, law. Give me a short title for it.
Okay. This law may be cited as Lagos State Civil Servants Law.
So maybe you can do that, but you can try to make sure that people can actually understand what you're trying to say. But that's typically the idea of what short title is. But make sure that from how they read they can deduce the meaning. Now, for example, I said that my owner is to say for disciplinary. So you might want to add a bit of that so that they know that okay, it's for disciplinary. So that's typically let's do another attempt. The Nigerian Law School Dinner Attire and Dinner Programs Regulation 1996. Give me a short title.
This law may be cited as the Nigerian Law School
Nigerian Law School.
Dinner Regulation Law.
So that's typically it. And make sure you put the year at the back. Take note, make sure you put the year at the back. Because even in your exam, if from this one, if from even legal drafting, when you're citing laws, make sure that I put the year. So that things that can give you first class, those
This for
minor things.
everything
Yes, the first time you like,
law.
yes. So it's possible that because of the laws are long, the first time you can write, for example, you can write company and 2020, and I write in brackets, comma 2020. Don't just write comma. Write comma 2020 so that subsequently you're writing comma 2020, comma 2020. So that they know that okay, you know what you're talking about. You understand? Mm-hmm.
For
Yes.
the first time you write it at all, you have to put the year.
Put it in full. No, put the year everywhere. Oh. I'm saying put it in full first because it's possible that you
Okay,
not be able to write it in full.
this is for full first, then year, and the short one subsequently.
Yes. So again, for example, come and act 20 in brackets, comma 2020. So it means going forward, they're probably writing comma 2020. Do you get?
Okay.
Not just comma. So that you can easily get
Okay.
your full
Now,
mark
thank
just
you.
in case. You're welcome. Also have the commencement clause. It indicates when the law comes into force or effect. Example is when you write in brackets. No, usually depending on how you write. There are two ways of writing it. Sometimes you write it like this in brackets. This rectangular bracket. 13th July. Maybe the law in that year. You can write 13th July 2020, or you can write commencement in brackets 13 July 2020. Commencement 13 July. So I wish I can snap this to you. Let me snap on English. I know that you can have an idea what I'm saying. It does not look entirely abstract. Let me just take a picture of that page I sent to the group chat so that as I'm saying it now, I feel like you will get lost. Let me see if I can just snap my notes. Mm. Let me snap what I'm referring to. Trying to just snap the notes. I'll send it to the group chat now so that at least what I'm saying will not look like abstract. So I'll just when I say all of this now, I'll just be reading it out so that at least you can follow. If in case you want to listen to this voice note later. But let me send it to the group so that you can follow me. Give me a second, sorry. Just give me a second. Trying to send it to you on the group. I'm coming. Mm. Are you seeing it? Let me know if you have seen it. Send it to the group.
Okay, I've seen it now.
So just read it out now. So those are ways of drafting commencement clauses. That you write 13 July 2020, or you write commencement and then in bracket 13 July 2020. Sometimes you just write that this law shall come into force on the 13th of July. So anyone you remember your exam, just know that you remember one thing. And if it's a retrospective commencement clause, you know, like this law shall or act shall be deemed to have come into force on so and so date. So most of the time, the question that you have in your exam will tell you which of them they are going to use. How they draft the question in your exam will determine. And they say that the law will come to force 3 months before. You should know, and another thing that you know the commitment clause. That means you know that okay, let me that's in the particular format. So the question tells you how to do it. Sometimes they also tell you that okay, the law that law will come into a date that will be given by authority. Put after you now draft it also in your exam. But if they don't tell you when it will come into force, you cannot write. Maybe they say that they did that. Maybe the governor assents to it. You now write this act shall come into force on the day that the president assents to it. So depending on what the question asks you, so make sure that you pay attention to what your question is dictating to you. Also, we have enactment clause, enactment formula. It states that the authority was enacted, and that it states the authority that enacts this. So, for example, we have enacted by, or is ever enacted by National Assembly of the Federal Republic of Nigeria as follows, or if it's a state one, maybe by Lagos State House of Assembly enacts as follows. So those are enactment clauses. Or if it's military regime, it could be the federal military government hereby decrees as follows, or the military government of Lagos State of Nigeria makes the following edict. So it does depend on how the question tells you to move. Also have interpretation clause. Maybe when you are drafting and you need to give an interpretation to what is given. Maybe some words that you wrote are really not things that people really understand, or are not generalistic meanings. Are you following? Or not generalistic meanings. You might want to put that kind of thing there. So for example, you write in to give people a meaning of what you're trying to say. So for example, if I'm saying that maybe my law I was drafting and I wrote favor. And me, favor does not mean like favor. Maybe it means command. I must write it that favor means command. I don't know if you get what I mean. So people that have seen those things will know that okay, this for a particular act this is what favor means. So if you act to draft in your exam, you will write it this way: in this law or act, comma, unless the context otherwise requires or provides. You now come forward. You now put colon. Then next line. Favor means dash. Regulation means dash. Do you understand? Do you understand?
Yes, ma'am. Yes.
Yes. Then also we now have that application clause. Where I said that one it indicates maybe the person, territory, or same that thing applies to. So for example, I say now when I was saying that civil servants law that I was giving earlier, I said civil servant. It means that any like now who apply to will be what? Civil servants. That one where I said law school now, who really apply to law school. So sometimes you can now, if you ask to draft in that company, you can say that okay, this law shall apply to all civil servants in Lagos State, all civil servants in Nigeria, all students of Nigerian law school in Nigeria. Something like that, depending on what the question is actually giving you to say. Also, we have duration, the period that sentence will stay in force. So that's you can write like this. This shall come into force until so day, or shall come to be in force until it is repealed, or shall come to be in force on August so year, and maybe 1st of August 2023, for example, and shall continue to be in force for 5 years. So depending on how the question dictates to you is how you will draft. So just pay attention. Don't just mindlessly learn this thing assigned to you. Pay attention to what the question is directing your mind to. And then we have principal segments. And yeah, I said that it has only two elements. I said it has establishment clauses. Establishment clauses is where Are you following me? Am I too fast?
Yes, I'm following.
Okay. Okay, so I said that exceptional clauses are usually used where legislation establishes a statutory body. So, for example, some clauses usually establish a, a body. For example, if you look at Kama now, Kama in the beginning part establishes Corporate Affairs Commission. Am I right? Am I right? Where it says
Yes, ma'am.
there shall be a body called the
Yes.
Corporate Affairs Commission. So that kind of clause now in that law is what they call a establishment provision. So it and so many times in that establishment part, if today just take your time to just look straight random meditation, you see that in that establishment part, not only does it talk about the establishment part where it's a military body, most times it gives you other portions like the membership, the management, general duties, finance, tenure of office, how to remove somebody, how to add, how to pay money to them. Like it, actually, those assignment courses really give those kind of details. So if they ask you to draft your exam, a way to draft is like saying there's established a body to be known as dash dash dash, or there shall be a body known as dash dash dash, or they shall continue to be established as a body known as. Basically, that's what establishment clause is about. This is me. On the next part, I will send a YouTube link where you can catch up on what you've gotten lost at. But just try to follow it from where I am, so I not be confused. So that's it. That's it for. You're welcome. You're welcome. So that is it for establishment clause. We also have administrative provisions, which consist of election of documents, use of custody or seal, the staff of the corporation meetings. This again, go back to your real life statutes. You will see all these things there. I want all of you to go there so that you actually learn from what we have shared there. Like you see the practical things so that what I'm teaching today can actually like stay in your mind longer. Do you get? So finally, we have miscellaneous parts. This one doesn't always come out in your exam, so at least you are free. But in case they give you MCQs, why that element I gave you before suffices. Why I said that under miscellaneous parts you have offences and penalties, you have miscellaneous and supplementary provisions, and finally you also have powers to make societal regulations. So finally we have final segment. I said that we have savings, we have repeal clauses, we have transitional provisions, we have explanatory notes, and so on and so forth. So if they ask you to draft a savings clause, you want to probably write save and except as otherwise provided, section that shall not be repealed under this amendment. Depending on what they ask you to do. But that, I'm just giving you a rough draft. So basically, that's how to draft under legislative drafting. So do you understand?
Yes, ma'am.
Yeah, welcome. So I intentionally took my time out to give you this one, even if it's not in our list of our timetable at all for this July series. Why did I give you? Because I am very certain I'm gonna come out in your exam, be it MCQ or in your theory. I don't want a situation where you do not know it. So please don't take property for granted though. Make sure that after this class, please try your hands on drafting these things. They're very simple, but if you don't know it, you don't know it. You get if you didn't day, you didn't day. So please just try to um after this class, just do a topic based practitioner and learn it. Do you understand?
All right,
You
ma'am. Thank you
understand?
very much, ma'am.
You're very welcome. So I think this brings us to the end of prophetic for today.